So our resource person has joined us, Dr. Avishek Chakraborty, Assistant Professor, School of Law, Christ, deemed to be University, who is the resource person of today's online workshop. Dr. Father Benny K. John, CSC, Principal of Holy Cross College, Agartala. Father Joe Paul, CSC, Vice Principal and Administrator of Holy Cross College. Dr. Shushovan Shengupta, IQAC Coordinator of Holy Cross College, Agartala. Mrs. Rupa Shaha, Coordinator of today's online workshop and Assistant Professor of Department of Business Administration, Holy Cross College, Agartala. Mrs. Sharmili Chakraborty, Head and Assistant Professor, Department of Business Administration and Joint Coordinator of today's online workshop. Esteemed guests and participants from various places, various states of India. A very good afternoon to one and all present here. I am Shubhajit Pal, Assistant Professor of Department of Business Administration. Welcome you all to this online workshop on intellectual property rights and IP management for startups. It's an absolute pleasure to me to guide you through this enlightening journey, being the host of today's online workshop. Due to an urgent work, our principal, Dr. Father Benny K. John, CSC, is not able to join us in this workshop, but he has sent his blessings to us and said us to continue the event. Now, without much delay, may I request Mrs. Rupa Shaha, Assistant Professor of Department of Business Administration and the coordinator of this online workshop, to enlighten us about the theme of the workshop as well as the introduction. Madam, over to you. Ma'am, please unmute yourself.
Am I audible?
Yeah, audible. Yes.
Okay. Good afternoon, everyone. I'm Rupa Shah, Assistant Professor of Department of Business Administration and the President of Institution Innovation Council, that is IIC 6.0. Would like to take the privilege to welcome our resource person, Mr. Avishek Chakraborty, sir, accuracy coordinator of Holy Cross College, and all the participants and faculty members, and the organizing committee for organizing workshops on IPR. Due to some technical issue, our principal and the vice principal of Holy Cross College is unable to attend this session, but he sent us warm regards and he's conveyed that to proceed the program without any delay. So, today we are talking about the IPR and the IP management for the new startups one. Today, with the initiatives of Innovation Institution Innovation Council, IIC 6.0, and the Department of Business Administration has arranged workshops on intellectual property rights and IP management for the startups. Nowadays, it is very important to understand and know about the legal rights and how it protects us from the different types of frauds, how it protects us, the creation and the innovation. IPR is one of the key elements nowadays. It differentiates a brand and creates a barrier for the competitors that enables the company to stand out in the market. Basically, IPR encourages innovation, creativity, and economic growth by providing incentives and exclusive control over the intellectual property rights. It fosters the competition and facilitates international trade by ensuring protection and enforcement its right. For the startups one, IPR is one of the important core things. What happens is that the startups once have a huge idea, innovative idea. But there is a problem, the stealing of an innovative idea. They have an idea which is unique one, but for keeping safe of their unique ideas, patents, trade secret protections, and different types of legal things will safeguard their intellectual property and prevent competitors from stealing their ideas. Today, in this regard, we have one of the experts. He is Mr. Abhishek Chakraborty, sir. He is from Bangalore, one of the law colleges. So I'd like to call Mrs. Sharmili Chakraborty, ma'am, Assistant Professor of Department of Business Administration, along with the head of the department, to introduce our speaker. Thank you so much.
Am I audible?
Yes, ma'am. You're right.
Thank you, Madam Rupa. Good afternoon, everyone. It's my pleasure to introduce and welcome our respected speaker today, Dr. Avishek Chakraborty sir, in this online workshop on intellectual property rights and IP management for startups, which is organized by the Department of Business Administration, Holy Cross College, and initiative by IIT of Holy Cross College. Dr. Avishek Chakraborty is an assistant professor at School of Law, Christ to be University, Bengaluru. Sir has specialized in intellectual property rights and his doctoral research focused on music piracy in film music industry in India. He has introduced and teaches specialized courses on various aspects of intellectual property rights for undergraduate law students. Sir has conducted training and orientation programs on industry practices and registration of intellectual property rights in India for engineering students. Dr. Avishek Chakraborty, as the coordinator of Intellectual Property Rights Committee, has been instrumental in preparing and publishing newsletter intellectually with the objective of disseminating knowledge about contemporary issues on intellectual property rights. He has authored and presented research papers in his areas of specialization extensively. Sir, I, on behalf of the organizing committee, welcome you to share your valuable words and expertise with all of us. Welcome and over to you.
Thank you, ma'am. Shall I start the presentation?
Yes, sir. Yes, sir.
Yes, sir.
Okay. Thank you so much. Thank you, Sharmili ma'am, for giving that introduction, for introducing me, and thank you, the organizers, for having me today for this particular presentation. Actually, this is my second opportunity to collaborate with Holy Cross College. Um, so the first time I think we had a session, I think 3 years or 4 years back,
Yes, sir.
and this is one more time. I'm glad to be a part of this particular queue. I'll just take some seconds to share the presentation. If anyone can confirm if the screen is visible.
Sir, it's visible.
Right. Thank you so much. So, as we know that today's topic for presentation is intellectual property management for startups. It is a very contemporary discussion and such a coincidence. I was having my class half an hour back in the postgraduate level here, and we were talking about the importance of startup and how intellectual property can be a very important tool for development of startup. And one more coincidence that right now I'm in Bangalore, which is considered to be a hub of startups, and there is a joke which is often shared that in every 1 kilometer in the city there is always a discussion on a startup, and this is one of the founders were able to establish a startup. Now, jokes apart, what I'm trying to discuss today is uh, how intellectual property can be a crucial tool for development of startup, and what are the while developing a startup. So I hope these brands which are visible in your screen are all known to you. For example, Redbus.in, Paytm, Byju's learning app, Oyo Rooms, Ola, Swiggy, Big Basket. There are so many other examples which we can cite here, which these brands are operating as started as a startup and are operating very successfully. And as we know that in this age of commerce, it is actually not the physical property but the intangible property that acquires more significance. I mean, it's very interesting to see that the Accenture building is maybe 200 meters far from my university, and all these big brands where we see that, of course, they have their big buildings, their furnitures, but what is the most important assets, be it Baiju, be it Oyo, or it Ola, it is the intellectual property rights or the intangible property rights. The entire business strategy is revolving around the way they are managing the intellectual property, and the future is how they effectively will be able to manage and utilize commercially their intellectual property. We know that the launch of a successful company can be often traced back to a single good idea. That idea probably made a long and complex journey from laboratory to market and survived when other better ideas were culled out because similar products already existed, lacked market appeal, or cost more than the market would bear. We know that intellectual property rights should therefore be fully integrated into and support the company's business strategy. IP should therefore be fully integrated into and support the company's business strategy. IP system allows innovators to control the destiny of their innovations, and that's why intellectual property rights helps to protect against initiate imitators and enable the companies to create a distinct identity to strengthen their market presence. For that matter, we can take the trademarks which are visible in your screen, for example, Big Basket, demonstrate how intellectual property can support successful implementation of the business model. Now, good IP management practice remains relevant throughout the life cycle of a business. Intellectual property is relevant as well as when startups are acquired by other companies. Now, startups should be equally aware that in addition to strengthening their competitiveness, the IP system can help them manage risk. A startup that ignores intellectual property may infringe the intellectual property rights of others also, and they can be blocked from entering domains that others already occupy or lose key assets to other companies that file for protection first. Such mistakes can be very much fatal. Now, we know what is intellectual property. I am sure that this audience is already aware of the basic concepts of intellectual property. Intellectual property refers to creation of minds. Such creations can have been recognized in law as a property that can be owned by the creator, provided the conditions set out in the law are satisfied. So, as you can see, that trademark can be used in developing a brand, patent can be useful in developing an invention, copyright can be used in developing artistic creative works. Then there can be trade secrets, there can be all other forms of intellectual property. So having an IP portfolio for any startup is very, very crucial. Now, when we consider creations of the mind, we refer to new product ideas, new ways of doing things, attractive designs, distinctive business signs, and creations such as music, song, paintings, and sculptures. Now, by their nature, these are intangible in the sense that we cannot touch, hold, or see the idea, though we can touch, hold, or experience the expression. For example, when we can have an idea of a logo, but we can have a protection only when you come out with a particular logo. For example, you are thinking about an idea of a story. Idea cannot be protected, but the moment you write down the story, you are eligible for copyright protection. So that's why the intangibility of such property creates a disadvantage and an advantage that are unique. So, because ideas are intangible, it is difficult to prevent others from appropriating and reproducing them. At the same time, many people can simultaneously use ideas without exhausting them or reducing their quality. Now, if you can think in terms of a particular song, I may find it difficult to prevent another person from copying a song I wrote, but many people can enjoy my song at the same time. So that is why it becomes very crucial when you are innovating something or you have a unique business idea. In how do you protect that particular idea, and how do you capitalize, and how do you monetize that idea? You need to be very careful in respect of protecting and keeping a fence around that idea, so that you are the one who can develop that idea and can get the benefit out of it. Now, when an idea reaches the point where it is expected to become the basis of a product or a service with commercial potential, it is important to consider as soon as possible how IP might facilitate its journey to market. Now, there are different forms of intellectual property that can be relevant. For example, when a startup that has developed a technical solution to a problem may consider obtaining a patent right for that solution. To qualify for a patent, a solution must be new, inventive, and useful. For example, um, you want to develop a technology which will help you to drive a car without having a driver. All we know, as we already know, that a brand called Tesla has developed this particular technology where they have patented this particular technology where a driver, without a driver, a car can be driven. So that is what I'm talking about, patent, right? Then, for example, trademark. It is not enough to develop a product or a service that solves a problem or improves existing solutions and protect it through IPR. A startup must also attract consumers and compete effectively in the marketplace. Consumers want to be able to find products they use easily and build a relationship of trust with them. When they find and like products, they feel attached to them and will probably buy those products again. It is important that a startup should consider as early as possible how it will create a distinctive identity of its product. Now, if you can see all these trademarks, we will be able to understand that how it has all made its own distinctive identity. The moment you see Ola, you will be able to understand that you were talking about an application where you can order, not an order, where you can book a cab, or you can book an auto rickshaw or any other modes of transportation. For example, when you see Swiggy, for example, you are not willing to cook, or the cook is not coming, so you want to have the foods of your local restaurants which you admire. So then you use the app called Swiggy. Now, if you take the trademark of Swiggy, you will see that there are so many other intellectual property which are associated. For example, the Swiggy logo with the S sign qualifies to be a trademark. Then the application, the computer application through which you are ordering food, that application as an algorithm can be a subject matter of copyright protection. So you see that the same product can have multiple intellectual property for that matter. Now, that is where we will try to understand that what are the different schemes that have been developed by the government for facilitating IP protection in respect of startup. Now, we know that startups have been recognized as a powerhouses of innate but immense power of innovation, technology, and ideas. So, the government of India launched the ambitious scheme, that is Startup India, Stand Up India, by announcing action plans and initiatives to support early stage startups. As a part of this policy, the government of India has approved and started the scheme for facilitating startups' intellectual property protection, uh, that is SIPP, to nurture their innovation and creativity and promote awareness and encourage IPR protection among startups. The scheme envisages to nurture and mentor innovative and emerging technologies among startups and assist them in protecting and commercialize it by providing them access to high quality IP services and resources. Just we should know that who can apply for such schemes. Here, when we use the word startup, we mean that startups are those entities which are incorporated or registered in India, which are not prior to 5 years, with annual turnover not exceeding 25 crores rupees in any preceding financial year, working towards innovation, development, deployment, or commercialization of new product, process, or services driven by technology or intellectual property. Provided that such entity is not formed by splitting up, reconstruction of a business which is already in existence. Provided also that an entity shall cease to be a startup if its turnover for the previous financial years has exceeded 25 crores Indian rupees, or it has completed 5 years from the date of incorporation or registration. A startup shall be eligible for availing the benefits of the scheme only after it has obtained certification from the Startup Certification Board. And what are the different means, and how do you commercially use intellectual property? Now, if you check the website of ipindia.gov.in, there is a document which they have uploaded which can be used as a guidebook in respect of how a startup can commercially use intellectual property rights or can successfully implement intellectual property rights protection. So there are different dimensions of it. I'm mentioning the four dimensions here. First of all, it is not only important to register one's own intellectual property, but also you need to respect others' intellectual property rights. So you need to know that if an invention is already protected by someone, how to take a license for that. The same is applicable for trademark or copyright. So the first important aspect is respect others' intellectual property rights. Now, how do you do that? You can check on the status of patents, trademarks which are already filed or granted or registered in India by logging to the website called www.ipindia.gov.in. You should make intellectual property protection an imperative strategy in business roadmap. So now IP protection has no longer remained an optional, strategy. No startup can develop without having an IP portfolio. So it is necessary that how do you develop that IP protection as an important business strategy. Not only that, you should be able to formulate and execute effective policies and strategies for protection of important rights. The example which I was giving for Oyo Room and for Swiggy, they definitely had a good IP policy. That's why commercially they have seen success. Now, you should also be able to register intellectual property rights. How do you register intellectual property rights? You can register the intellectual property rights both by going to the IP office and also digitally or online. You can register by logging into the same website, that is ipindia.gov.in. This website can be used for e-filing of patents, designs, and trademarks. Now, I just want to share one example here before we go to the different forms of intellectual property. This is an example where intellectual property has been used as a means of social entrepreneurship, and how a startup can be crucial in the in facilitating social entrepreneurship. So here I am giving reference to the picture. The person which you can see in the screen is of Professor Saji Verghese. He is a professor of English at Christ Gimtubi University, Bangalore. Now he has developed a particular invention which you can see that there are certain straws in his hand. I'll explain what it is, but he has founded a Bangalore based startup which is known as Sunbird Straws. Now it helps organizations to fulfill its mission of meeting the sustainability goals towards a greener and cleaner planet. Now he has invented something called biodegradable straws. Right now, the purpose of this organization, that is Sunbird Straws, the startup, is to reduce the carbon footprint, to remove property by empowering rural women, to contribute towards clean air and water by reducing the use of plastic and paper alternatives. Now, the invention I'm talking about, it's 100% biodegradable, and these straws are created with a chemical-free process. And these biodegradable straws are made from coconut leaves and palm leaves. Right? These are multi-layered product with natural antifungal and hydrophobic outer and inner walls, and it can be used it in any drinks for up to 3 hours. Now, I mean, I'm very proud to announce that this invention, this biodegradable straws, the patent for which has been granted in a record time, and this is one of the fastest granted patents which we have seen in our country. A Bangalore-based IP firm called Banana IP actually helped in filing the patent application for for these biodegradable straws. So this is one example where a startup, by effectively using intellectual property protection, can contribute in social entrepreneurship. For your information, the startup has not only patented the straws but also has obtained a trademark protection for the logo Sunbird straws, and also have obtained design protection not only in the front of IP, but this organization has become a major source of employment for many rural women. So I just wanted to share this story with you. He has been recognized both nationally as well as internationally. Now, among different forms of intellectual property, I'll start with patent protection first. You know that patent is a statutory right for an invention granted for a limited period of time to the patentee by the government in exchange of full disclosure of his invention, for excluding others from making, using, selling, importing the patented product or process, or producing that product for those purposes without his consent. The example which I put in the screen is the patent which was granted to Thomas Edison for his invention in the form of electric lamp, which was patented on January 27, 1880. So patent is given for innovation. So when a startup has an innovation, both in the form of product or process, they should apply for patent protection. What is patent? Patent means a patent for any invention which is granted under the Patents Act. Now, patents are certain exclusive rights which are granted to a person who has invented a new and useful article. It consists of an exclusive right to manufacture or use the new article invented for a limited period of time. In effect, grant a patent right would mean an exclusive right to prevent any unauthorized use of the underlying patented technology. Just a second. Yeah, the objective of patents is, of course, to gain commercial advantage. So the moment you have invented a product or process, if you obtain a patent protection, it is as good as putting a legal fence around your invention, and no one can use the invention without your consent. That's how patents help you in gaining commercial advantage. Other than gaining commercial advantage, it also encourages in scientific research, development of new technology, and in development in progress of industry. Patent is granted both for product as well as process. So it can be chemicals, it can be medicines, or it can be any product for that matter. And patent is granted not only for product, it is also granted for the process to make that particular product. So the example of biodegradable straw, which I was sharing with you a couple of slides back, that can be an example of a product patent. So Professor Sajeev Verghese has not only obtained a product patent for the biodegradable straw, but also he has obtained a process patent to manufacture that biodegradable straw. Now, what does a patent do? It protects your patent for 20 years. So the duration of patent protection is of 20 years. So it means that no one else can manufacture the product, and someone can has to pay royalty anytime your invention is required to be used. You can block competitors, and after 20 years technology goes to the public domain. So it means that after 20 years the patent expires and it falls into public domain. Anyone can reproduce and make a copy of the invention without taking permission of the patent holder. What can be patented? As I told you, it can be a process, for example, process for making a chemical compound. It can be a machine, for example, television or smartphone. It can be a manufactured article, for example, a bicycle or a table. It can be a composition of matter, for example, a shampoo or a cleaning solution. What cannot be patented? An idea or suggestion cannot be patented. A scientific theories or mathematical formula cannot be patented. For example, E is equal to mc square, because they are discoveries. Anything which is not an invention but a discovery cannot be patented under the Patents Act. For example, biological process for the production of plant or animal, for example, photosynthesis, cannot be patented. A method of treatment or diagnosis, for example, biopsy, for example, bypass surgery or cataract surgery. The method of treatment or diagnosis cannot be patented, but the apparatus or the instruments used for the same can be patented. Then animals as such cannot be patented. nor the law of nature. For example, gravity can be patented because anything which is in the form of discovery does not fall under the purview of Patents Act. So, if, for example, someone discovers a new metal into the periodic table, that will not be a subject matter of patent protection because it was already there in the nature. Someone has merely found it, and there is no invention involved in it. What is an invention? Invention means a new product or process which involves an inventive step and capable of having an industrial application. What do you mean by new or novelty? It means the invention must not be published in India or elsewhere, and in prior public knowledge or prior public uses within India, or it should not be claimed before in any specification in India. Let me share an example here. In United States, couple of years back, there, I mean, around 10 to 15 years back, there was there were two Indian scientists who claimed that they have developed a new variety of basmati rice, and they applied for a patent protection for a new variety of rice, and they called it Texmati. Why Texmati? Because it is from the Texas region of the United States. Now, this rice is already a known product. It is already grown in India as well as in Pakistan. So that is where Indian government raised an objection to it, and later on the patent on this Texmati rice was cancelled, was revoked because it lacked novelty. It was not having the novelty requirement for an invention. Same thing happened when the use of a turmeric powder, a product based on use of a turmeric powder, was patented in United Kingdom. Now we know the role of turmeric powder as a healing compound for a long period of time. In India, haldi is used for healing purposes for a long period of time. So similarly, that patent was also revoked because the use of haldi didn't have any novelty for that matter. The next requirement for patent is having an inventive step. Inventive step, it's a feature of an invention that involves technical advancement as compared to the existing knowledge, or having economic significance, or both, and makes the invention not obvious to a person skilled in the art. Let me give an example for this. For example, we know the application of washing machine. These days, washing machine can not only clean the clothes but also can dry up the clothes. Now, say after 10 years or after 5 years, there is a washing machine which not only helps in washing and drying the clothes, but say there is a feature which can also help in folding the clothes. Now, this feature of folding the clothes will be considered as an inventive step, and that's how it will help in granting an invention for that matter. Now, industrial application. Invention should be capable of being made or used in any kind of industry. So that's why industry does not mean that it should be in an industrial setup. So we will once again take the example of biodegradable straw, and we'll see that it has an industrial application, means it is capable of being made or used in any kind of industry. Who can apply for a patent? Right? So the patent can be applied by the first and true inventor. Just a second. Right. So, first and true inventor can file an application for patent, or the assignee of the person claiming to be the first true and inventor, or the legal representative of a deceased person who is entitled to make such application. Now, in your screen, you can see two persons. First one is Mr. Tesla, and the second one is Mr. Elon Musk. I think, there is no specific connection why I mentioned there, but they are all innovators, right? Elon Musk is the owner of the brand Tesla, right, which is named after another scientist, right? So in India, the person who is first to file the application gets a patent. Now there are different stages where the patent application can be filed. So first, the application has to be filed, and within 18 months, the application has to be published. After that, there is a stage called pre-grant opposition, where if anyone having any opposition with the invention can raise a pre-grant opposition, and then there has to be a request for examination of the invention. Request for examination implies that the patent controller will go through your invention and see that whether all the criteria for patentability are granted or not. For example, whether it is novel, for example, whether it is having an inventive state, or whether it is an industrial application, or whether any of the prohibition applies or not, is applicable or not. In India, inventions related to atomic energy, even though they are patentable, but cannot be granted patent in India. After request for examination, there is an examination conducted by the patent office, and based on the report, your patent can be either granted or rejected. And even after your patent has been rejected or granted, if your patent has been granted patent protection, your invention has been granted patent protection, there is a provision for post grant opposition. Once you pass that stage, then the patent remains valid for 20 years. This 20 years duration is calculated not from the date of grant of patent, but this 20 years duration is calculated from the date of filing of the application. Now, when you are required to file a patent application, there are two types of specification. The application is known as specification. There are two types of specification: provisional specification and complete specification. If your invention is not ready and you have only the prototype, you can file a provisional specification, and within 12 months of the filing of the provisional specification, you can file the complete specification. If you fail to file the complete specification with filing of the provision specification, your application will be lapsed. So the complete specification contains 8 different components. There should be a title, field of invention, background, summary, list of drawings, detailed description, claims, and finally it should have an abstract. Now, both at the time of filing and after filing, there are certain forms which are required to be filled. What are those forms? Form 1, which is for application for grant of patent. Form 2, which is for the specification and the drawings. Form 3, which is the statement as well as the undertaking regarding the foreign applications. Then Form 5, which is declaration of inventorship. And Form 26, which is about power of attorney. After filing invention, you have to fill the Form 9, which is request for early publication, Form 18, which is a request for examination, and Form 18B, which is a request for expedited examination. So these are the legal documents or the forms which were required to be filed during the application process of patent specification. Now, this is in graphics the entire process for grant of patent. So first of all, you need to have an idea. And once you have the idea, you need to conduct a prior art search. Now, after you have conducted a prior art search, the purpose of which is to find out that whether a similar patent has already been granted for that invention. Now, there are registered patent agent or attorney who are qualified to do such kind of prior art search using the pertinent database. Now, the filing of patent application can be excused for 30 seconds.
Sure, sir.
Just a second. Student has come. Just a second. Yeah, sorry for the interruption. So anyway, so when you're filing the patent application, as I told you, that if you have the invention ready, you can directly go for complete specification, or alternatively, you have to file a provisional specification, and within 12 months, you have to file a complete specification. After that, you need to publish that in the website of the patent office, after which you have to request for examination, where the patent office will examine your invention and will file an examination report. If they are okay with your invention, they will directly grant you patent. And if they are not happy, they are not satisfied with the patentability, they will ask you to defend that what are the problems in respect of that invention. Based on that, the examiner will either patent your invention or they will refuse your patent application. If the patent application is refused, then you can prefer an appeal against the particular decision. Moving on, um, how to file a patent application? It can be filed through online by going to this website called ipindiaonline.gov.in, or it can be filed by way of post or can be submitted in by hand at the office. Now there are four patent offices in India: the Chennai the Chennai Patent Office, Mumbai Patent Office, the office situated in Delhi and Kolkata. So for the state of Tripura, the Kolkata Patent Office will have the jurisdiction over the state of Tripura. So that's why the patent office is headquartered actually at Kolkata, with branches in Chennai, New Delhi, and Mumbai. But the Office of Controller General Patents, Design and Trademark is in Mumbai. The Office of Patent Information System is at Nagpur. So if you want to file a patent application for an invention, the correct patent office would be the patent office which is located in Kolkata. Now, coming to the next form of IP, that is copyright. Now, copyright is another form of IP which protects creativity, creative expressions. For example, patent protects novel invention. Similarly, copyright protects original expression, creative expression. Now, as you can see that there is a poster which says, reading this text constitute copyright infringement, you are under arrest. Can you say that whether this is a correct observation? Definitely not. Because if you are reading this particular poster, you are not making a poster copy of the poster, and hence you are not violating for copyright. So the next portion of this presentation will be dedicated towards understanding what is copyright and how do you obtain copyright protection. Now, in the picture which you can see in your screen, you will see that the copyright information is available. On your left hand side, you will be able to find the copyright symbol, and next to it, the name of the author, that is Gurucharan Das, is mentioned. You see that even though the book is published by Penguin Books Limited, the copyright of the book is belonging to the author. On your right hand side, we are talking about a book which is authored by Shashi Tharoor. You see that there is a mention of the copyright symbol, and next to the copyright symbol, it is mentioned as Shashi Tharoor. This book was published in 2016. So, copyright is granted over original expression in the form of literary work, artistic work, dramatic work, etc. etc. Now, you will see that in both the picture, there is one expression which is common. In both the picture, there is one sentence which is present, that is, all rights reserved. You can see that in both the picture, there is a mention of of a phrase called all rights reserved. This all rights reserved means all copyrights reserved with the author. It means making a copy of the book without the consent of the copyright owner is a violation of copyright law. And this is what is copyright. What is copyright? Copyright is granted to authors of work, musical work, artistic work, dramatic work, sound recording, or cinematograph work. Now, the point to be noted is that copyright is granted not to idea but to expression of idea. And unlike patent, copyright registration is not compulsory. Copyright registration is optional and voluntary. Even if you do not register your copyright, if your work is original and if you have not copied from anyone else, your work is entitled to get copyright protection automatically. Now, in case of copyright, the author is the first owner of the protected work. For example, any one of you have written a research paper, right? So you are the author of the research paper, hence you are the first owner of the copyright. You have a camera, you have taken a picture, so you are the copyright owner of the particular photograph. Someone is painting a particular picture, you are the author of the artistic work, and hence you are the first owner of that particular painting. But there is an exception. So if someone is working under an employer-employee relationship, for example, the question papers which I draft as in the role of my as a role of teacher in this particular university, all the question papers which is drafted by me for mid-semester examination or end-term examination, being a full-time employee of this particular university, the copyright of the question paper goes to the university, even though I am the author. So, in case a work is created during the course of employment, in that case, the employer becomes the copywriter. For example, there's a journalist who is working, say, with the Hindu. So he is a full-time journalist who is working with the Hindu. So in that case, even though he's the author of a news article, the copyright of the news article will belong to the Hindu. But if you're working as a contract for service, and if you're not in the full-time employment, say you are working as a freelancer, in that case, the copyright will be belonging to the person who is written it. That means in case of a freelancer, the copyright will be with the freelancer. Now, what does copyright mean? I'm so sorry, sir. Just a second, sir. Yes, sorry, I'm back now. Copyright refers to the exclusive right to reproduce the work in any material form. Means, say there is a book, someone is making a photocopy of the book and illegally selling the book commercially. That is not allowed. Say there is a book which is written in English. You want to translate the book in Bengali. You cannot translate the book in Bengali without taking permission of the copyright owner. Say a producer of a cinematograph film wants to adapt a particular book and convert it into a movie. So that adaptation right also belongs with the copyright owner. So you'll see that there are many movies which are adapted versions of a book. So in all those cases, permission is required to be taken from the copyright owner of that particular book. Also, when you are playing sound recordings or music in public, or you're communicating the work in public, for that matter also, say, for example, if you're playing music in a public place, say music is being played in a restaurant, in a mall, or in railway station, in airport, for all that matter, permission is required to be taken from the copyright owner. So as I was telling, that there are different subject matters which falls under copyright protection. For example, musical work, pictures, computer code, website design, video, cinematograph, film, sound recording, literary work, motion pictures, dramatic work, choreography. These are all subject matter of copyright protection. As we are discussing that, creative expressions are subject matter of copyright protection. As I was telling, that in order to secure copyright, there is a formality free protection is available. Means the registration is voluntary, and registration does not, as a matter of law, establish that what is registered is in fact and in law a copyrightable subject matter. And just like in case of patent, the duration of patent protection is 20 years. In case of copyright, the duration for literary, dramatic, musical, and artistic work which is published during the lifetime of author is lifetime of the author plus 60 years. For example, now the Tagore's all the works which are created by Rabindranath Tagore are now in public domain, because the copyright over all those songs, all those literary works are now in public domain. How it happened? So the copyright is valid during the lifetime of Rabindranath Tagore, and after his death, till 60 years, the copyright over all the creations were held by Vishwabharati University, which is located in Shantiniketan in West Bengal. So the duration of copyright protection is lifetime of the author plus 60 years. In other type of works, it is 60 years from the date of publication. So once again, for copyright protection, the duration is lifetime of the author plus 60 years. Now, this is the official website of the Copyright Office. You can see on your left hand side, there are different online services which are available. For example, you want to file an application online, you can avail the option called e-filing of application. Then if you want to check the status of your application, you can click the status of application. So what are the checklists which are required to be looked into before filing the application? You can check that. The details of processing fee can be checked, right? So you can, how to upload the document, the manual is available. So these days you don't have to actually go to the copyright office. The copyright office is located in sector 14 of Dwarka in New Delhi. But actually going to the office and filing of application is not required. You can file the application by availing the online mode. Now, the next form of intellectual property which we will be talking about, other than you know patent and copyright, is, I hope you can guess from this picture, we are talking about trademarks. You see that this is a very interesting picture. I hope you are able to identify which one is the original brand, right? So on your left hand side there is something called Belsri, then there is Belsari, then there is Brisley. So I hope you can understand that from the left, the second bottle is the original Bisleri bottle. So what through this picture I'm trying to explain or demonstrate the significance of trademark protection and how it is significant to not only have your trademark registered but also to legally enforce your trademark right and stop the counterfeiters from using your trademark. Now, as I was giving the example of the biodegradable straw, and I was telling that how Professor Saji Varghese startup was able to register his invention, you know, through the mechanism of patent. Uh, Other than patent protection, he has also registered the Sunbird logo as a trademark. So sometimes, as I was telling, that it is not enough only to develop a product or a service that solves the problem or improves the existing solutions. It is also necessary that the startup must also attract consumers and compete effectively in the marketplace. The consumers should be able to find products that they need easily and build a relationship of trust with them. A very easy example can be, say, the toothpaste, which we use in the morning, right? Now, some of us have a preference towards Colgate. Someone may be like having preference towards Anchor. Someone may be liking Pepsodent. Now, if you're going to a supermarket, if you're going to a particular um, to a shop where you want to buy toothpaste, every time, instead of describing the product, or how do you identify which one is Colgate, which one is toothpaste, or with Pepsodent, or which one is Anchor, the mechanism with which you can immediately identify your desired product is the trademark. So if you have a preference for Colgate, you can quickly identify the product. So that is why, in order to make your product available to the public and in order to make a distinctive identity, right? So when consumers find and like product, they feel attached to them and probably will buy those products again. So that is why it is important that a startup should consider as early as possible how it will create a distinctive identity of the product. Now that is where the trademark comes into picture. Now you see that we discussed that how patent is helpful for protecting innovation, how copyright is significant for protecting creative expression. But what about logo? What about a symbol that helps you in that helps the consumers in identifying the brand which you are, or the product that you are selling? So as per the Trademarks Act of 1999, trademark means a mark which is capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, and it may include shape of goods, their packaging, and combination of colors. I try to make the concept simple and without legal jargons. What do you mean by mark? A mark can be a device, a brand, a heading, a label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination there. Why I am referring to the picture of respected Mother Teresa is, I am not sure whether you are aware, the sari, that is the blue border sari, the three blue stripe border sari has been given a trademark protection 2 years back, and that was done to recognize the sainthood of Saint Mother Teresa. Right? So you see that color and combination of color, it's not color per se, but combination of colors can be considered as a subject matter of trademark protection. For example, you have seen the Penguin publishers, the Penguin logo, right? So the picture of Penguin as a logo can be considered as a trademark. Then I mean, there are so many examples around me, and around you can look around yourself and can find out what are the different trademarks which are available. Say the particular ceiling fan which you, I understand this is summer, so either air conditioner or a ceiling fan would be there, or any kind of fan would be there. You can see the mark there. For example, the tire company, Madras Rubber Factory, they have the trademark, right? So a person holding the tire. So that is one example of a trademark. Here there are some examples. See this MRF, this device, this image can be considered as a trademark with the abbreviation MRF, right? Then Levi Strauss and Company, the label of this jeans can be considered as a subject matter of protection. Then I'm not sure whether you're aware of this, the Toblerone chocolates. The shape of the Toblerone chocolates have been registered as a trademark. Now, the name of a medicine can be registered as a or the brand. For example, Falcitab is an example, right? This is used for treating falciparum malaria. So that's why you see there's a picture of mosquito. So this Falcitab can be registered as a trademark. Then I am sure all of us use Amazon these days. So this Amazon again can be considered as a, this is a word mark. This can be registered as a trademark. So you see that this arrow that goes from A to Z. This shows the wide selection of products from the online store set. So again, I think you can identify the logo of Audi or Mercedes, which are used for automobiles or motor vehicles. There are different kinds of trademarks, right? So different kinds of trademarks which are registered, can be registered under the provisions of Trademarks Act. The first example can be marks on goods, right? For example, dairy milk, right? So Cadbury dairy milk is used to sell chocolates. So that is an example of trademarks. Then next to dairy milk, you can see the logo of ITC audits. So that example of service mark. So any manufacturer or product can use it as a trademark. But for example, Apollo Hospital, for example, Airtel or State Bank of India, right? These are providing services. So these type of trademarks are also known as service marks. And then there is something called certification mark. So when you are buying a food, you must have observed this symbol of FSSAI, that is Food Safety, forgetting the full form of it, Safety and Security Authority of India, correct? So the FSSAI mark is an example of a certification mark. Why it is an example of a certification mark? This mark doesn't help the consumer to know about the origin of the product. For example, Cadbury Dairy Milk, if you see this particular mark, you know that this is a chocolate which is being manufactured by Cadbury. But if you see the FSSAI mark in the wrapper of Cadbury Dairy Milk, you will be able to understand that this chocolate is fit for consumption. So that is why the purpose of certification mark is to certify that the goods which are manufactured and sold, they are complying the statutory or the other requirements. Then the example of silk mark, right? For example, while buying a silk sari or any clothes which has silk, right? If you see this particular silk mark, it is an assurance of the quality of that particular mark. And then there is something called collective mark. Collective mark is used by a group of or an association of persons. For example, the Chartered Accountant mark. This is an example of a collective mark, right? So this is used by all those people who belong to this particular profession. Then Indian Medical Association, the doctors use this particular symbol, right? This is not a trademark. This is a collective mark. The lawyers also use a particular mark, which is known as collective mark. Now, there are different categories of trademark based on their distinctiveness. Now, if any startup wants to register their trademark, they need to understand that what category of distinctiveness they are referring to. So, there, if the trademark is not distinctive, the trademark registrar, the Controller General of Trademark, Patent and Design may refuse to register your trademark. So that is why it is important to understand what are the different categories of trademarks. So, for example, fanciful trademarks. What is fanciful trademark? Fanciful trademarks are made up words which are invented to be used as a trademark name. For example, Kodak, Exxon, Polaroid. These are all invented words, means they do not have a dictionary meaning on their own. So that is an example of fanciful mark. Next is the example of arbitrary mark. What is an arbitrary trademark? An arbitrary trademarks are used that have a real common meaning, but they're completely unrelated to the product or service. The difference between fanciful and arbitrary trademark is, in case of fanciful trademark, the words are not having any dictionary meaning. But in case of arbitrary trademark, the words may have a dictionary meaning and they may not be an invented or coined word, but they have no connection to the goods or services they are being sold. For example, you can see the Apple mark, right? So the Apple mark, which is used in iPhone or in MacBook. So when you are using this half written Apple logo for selling electronic gadgets, this right? So it is unlikely that a dove, the bird will actually use a soap, right, for whatever purpose it is. So dove is an example of an arbitrary mark. Then we have the category in the form of suggestive trademarks. Suggestive trademarks are named after a characteristic of the product or service. Now you see that there is something called descriptive trademark and suggestive trademark. Suggestive trademark does not describe the trademark, but it is designating the kinds of goods or service it is related to. For example, Jaguar. Jaguar is used in respect of automobile, right? Vehicles. So Jaguar, the animal signifies speed, but it is not describing the product. Then Microsoft, which is used for software. Then Netflix. I hope all of us are aware of this particular trademark. So you see that Netflix is in respect of entertainment. Microsoft is used in respect of software. So here the trademark is suggesting the kinds of goods and service, but they are not describing. In comparison to suggestive trademarks, if you refer to descriptive trademarks, descriptive trademarks are a description of the product or service. For example, if you see the trademark Sharp for selling television, so that would be a descriptive mark. You are describing a feature of the particular mark. British Airways, Best Buy, these are all descriptive trademarks. Generally, descriptive trademarks are not registered. They're not registered because they are not having distinctiveness, but on certain exceptional cases, if they can prove that they have acquired distinctiveness, then they can be registered. The same is the case with generic trademark. These days, generics are those trademarks which cannot be protected as the simply a generic description of the products or service. So these words, for example, Band-Aid, even though we are using a medical adhesive manufactured by any other company, still we use the word Band-Aid. Say you are having a paracetamol, so even though you are having, what do you call, Calpol or any other brand, we tend to say that we are having aspirin. Then, for example, Thermos is the name of brand, right? So Thermos is the name of a brand which sells utensils and other, for example, water bottle. So many times we are using a bottle which can preserve the temperature, which is manufactured by other company, but still you use it. So that is an example of a generic trademark. I have observed that in many rural places, or not why to in rural places, in many places when they buy a almirah, even though they are buying an almirah which is manufactured by Nilkamal, they say that they have bought a Godrej. So the Godrej has become synonymous with the trademark with Almira. So that can be an example of a generic trademark. Now, what to avoid when you are selecting a trademark? Generic terms. For example, if you're selling chair, you should not use the word chair. You can use Nilkamal or any other trademark, right? Nilkamal is a arbitrary mark. Is an arbitrary mark because Nilkamal, the word Nilkamal, has nothing to do with chairs. Then descriptive terms, sweet to sell chocolates. So you cannot use the term sweet to sell chocolates. Deceptive terms, for example, pure wool for 100% synthetic material. You are selling synthetic material, but you are using the word pure wool. So it is deceptive. You cannot use it. So then the marks and terms which are contrary to public order, or morality cannot be registered. Generally, trademarks which has the potential to hurt the religious sentiment, they are not registered. Flags, armorial bearings, official hallmarks, uh, this emblems cannot be registered as a trademark. For example, Ashok Chakra cannot be registered as a trademark. Now, if you are planning to register a trademark, first of all you should create a distinctive trademark, inherently distinctive mark. For example, arbitrary marks and logos such as Apple for computers, suggestive marks for Sunny for heaters, a mark which is easy to memorize and pronounce with a positive connotation and that fits products or image of the business. That's why you should go for a trademark which is easy to speak and spell in case of wordmark, or appealing and easy to remember or recollect in case of suggestive mark. And the registration of trademark is done by the National Trademark Registry and valid in that country. So if you're registering a particular trademark in India, it will be valid only in India until and unless you go for an international registration. Recently, the trademark Amul has won a trademark case in Canada, but Amul has registered its trademark in Canada separately. So the registration which is done in India is not applicable in the country of Canada, because intellectual property rights are territorial in nature. So the registration which is done in one country is valid in that particular country only. So, and that's why registration is made after examination and publication, and period of registration is for 10 years, but it can be renewed indefinitely. So in comparison to copyright and patent, trademark registration is for perpetual. So, but every 10 years you have to renew it. Say a trademark registration has been done today, 27th of March 2027. Every 10, that means in 2027, 2000, sorry, in March 2034, in again on March 2044, you have to periodically renew your trademark. So the period of registration is initially given for 10 years, and after every 10 years you have to renew your trademark. What are the different steps for registration of a trademark? You need to select a distinctive trademark. You need to apply for registration, an appropriate form with appropriate fee, classify your goods and services and specify them properly, apply before the appropriate office of the trademark registry. Right? So, for example, for the state of Tripura, the Kolkata Trademark Registry will be having the jurisdiction over the state of Tripura, and you should respond to the office queries or notices properly and on time. What is protected and what is not protected, as I told you, the right to use trademark in relation to goods and service as registered are protected. You must have been seeing this R sign and this TM sign. This R sign signifies that the trademark is already registered, and this TM, use of this TM sign means two things: either they have applied for registration and the registration is pending, and alternatively it can also mean that someone has not applied for this trademark and they're using it as a trademark, right? So this is the difference between R and TM sign. This is the website. You can see this is the official website of the Controller General of Patents, Designs and Trademark, where you can file an application for trademark registration online. Now, on your right hand side, you can see a form, that is form TMA. This form TMA is required to be filled where you are intending to file a trademark application. Trademark application for registration. You see that in the first point, nature of the application, it is mentioned that who can file this application. Sorry, not in one, in two. Whether the application has been filed as in case of startup, small enterprise, requisite certificate should be provided. As I'm telling that if you are filing a trademark application as a startup, you need to give a registration certificate by the Startup Certification Authority. On your left hand side, you will see the amount of fees that is required. So where the applicant for trademark registration is an individual or a startup, in that case, for physical filing, that is going to the trademark registry, you have to file. If you're filing trademark application, you have to pay 5,000. If you're filing the trademark application online, you have to pay 4,500 rupees. So you see that if you're not filing application as a startup, you have to pay around 10,000 rupees. But if you're filing the application as a startup, you have to pay around 5,000 rupees. Now, these are certain cases where use of deceptively similar trademarks are prohibited. few months back, I mean last year, there was a case where Oreo, which is owned by Britannia, they filed a case against Fabio, and Oreo filed a trademark case against Fabio and got an injunction because you see that the appearance of both the trademark is very much similar. One more example I have found recently, for which there is no legal case which was filed, but you can see that on your left hand side, the original Amul product is there, but on your right hand side, there is a counterfeit product, that is Asmul. So that's why I'm telling that trademark protection is very important, not only to build your distinctive brand value in the market, but also to stop your counterfeiters from now, the last form of intellectual property which I'm talking about is trade secrets. Trade secrets talks about those information, of course, which is secret. The information that's a secret that is not generally known or readily accessible to those who usually deal with such information. Then those information which has a commercial value, the information that has commercial value because it's a secret, and the information that is subject to reasonable measures by the rightful holder of the data to keep it secret. One of the example of trade secret is the secret formula of the beverage Coca-Cola. Now, KFC's the recipe of KFC is also an example of trade secret. In India, please note that there is no statutory law, there is no enacted laws which are there to trade secrets are not protected through a law, right? So you see that if you are starting a startup, let me give one example here. A particular case, they say that you are going to start a business called Inomart, which specializes in developing innovative technologies to enhance the e-commerce shopping experience. Now, how this Inomart could manage its intellectual property? First of all, you are required to identify the key IP assets. So, Inomart should identify the several key intellectual property assets which are associated with its business. Now, Inomart should identify these intellectual property assets and identify the key IP assets which are associated with its business. Now, for creating e-commerce platform and application, you can have a copyright protection on this. So it is necessary to develop a comprehensive IP strategy. This Inomart can develop a comprehensive IP strategy to protect its valuable assets and gain a competitive edge in the e-commerce industry. It can prioritize patent protection for its unique technology by filing patent application to secure exclusive rights to its innovative features and functionalities. It can register the trademarks for its brand identity and product names to establish brand recognition and prevent unauthorized use by the competitors. It can implement strict confidentiality agreements with the employees, contractors, and partners to protect its proprietary information and trade secrets related to its innovative technologies. So Inomart should ensure that its own or has the appropriate right to all the IP assets that is developed or used in its business. It includes IP ownership provisions in employment contracts and agreements with third-party developers, consultants, and collaborators to secure ownership of inventions and creative works. So Inomart should file for legal protection for its IP assets to establish enforceable rights and to prevent unauthorized use by way of engaging qualified patent attorneys to draft and file patent application for its innovative technologies, seeking broad protection for its unique feature and functionality. So you see that this is how you can use the platform, you can manage your intellectual property to commercialize and protect intellectual property. And just a second. This is where I conclude my presentation. I hope this presentation have been helpful to you. Thank you so much for giving me this opportunity to share my thoughts on this topic. If you have question, I would be happy to answer.
Thank you so much, sir, for your session. Sir, we have few questions from our participants. They have given in the this WhatsApp group. So I'll ask
Okay.
Mr. Achinta Bhattacharjee, Assistant Professor of Department of Business Administration, to please run this question and answer session. Over to you, sir.
Okay.
Uh,
Hello.
yeah, you're
Good
audible.
Hello.
afternoon. Yes.
Okay.
Yeah.
Good afternoon, all. Good afternoon, Avishek sir. Few
Good
of the
afternoon.
participants have already sent their questions in the WhatsApp group. So I will be taking the questions one by one, and I would request all the participants, if you are having any question, so please send it in the WhatsApp group so that I can ask on behalf of you to Abhishek sir. So Abhishek sir, can we start?
Yes. Yes. Please.
Okay. Okay. Thank you, sir. The first question has been asked by Mr. Devdeep Shikdar sir. He is having one, two, three questions. So first question is, sir, as you have said about patent of electric bulb, and it was discovered by Thomas Alva Edison, as we all know. So his question is, uh, Alva Edison's patent was an improvement on electric lamps,
Yeah.
not
Yeah.
invention of them. It was an improvement on electric lamps. So
Yes. A
Edison's
patent can be
Ed-
granted on. Sorry. Sorry. Finish your question. Sorry.
okay,
Yeah.
so Edison's material was about the first electric bulb was created by Humphrey Davy in 1802.
Correct. Correct.
James Brown Lindsay invented light bulb that could last 1000 hours in 1878. Then in 1880, Thomas Alva Edison just made an
Correct.
improvement, and because of that, he got a patent of light bulb as an inventor.
Yeah. Yeah.
So he should have got the patent for improvement, not for the product itself. So is
Yeah.
it correct, or it is a violation of
Yeah,
that
so
patent?
there has been quite a controversy about that particular invention, that whether it was actually Thomas Alva Edison who should get credit for that invention. Now there are many facets to that particular aspect. Now, see, technically speaking, improvements can also be granted patent. Technically speaking, if the improvement satisfies that criteria of patentability. So answering that question, that improve whether improvement can get a patent, technically yes. But in that particular case, see, if there is an application made by an inventor, and if it is not correctly claimed as an invention, or if it is someone else's invention, there is also a procedure to object it. So say I have, Thomas Alva Edison has filed that application for patent. Now, as you have given reference to so many inventors who have contributed in that, they should have raised an objection that this application made by Thomas Edison is not a correct one. So there should have been an opposition if it is proved, or it can be claimed, or it can be proved that it is not his invention. So, if because in India at least, the patent is granted based on who files the invention first. So that's why the Indian Patent Office follows the system of first to file system. So if I am filing the invention first, so I would be considered as the inventor. Now, if I have stolen someone else's invention, then if when you remember, I was explaining the process after publication of the invention, there is a process called pre-grant opposition. So in that case, those who have a objection to that particular patent, they should say that, and they should establish that the patent is not novel, that the person who has applied for patent is not the true and first inventor. So I mean, we cannot go in time machine back and change the patent which was granted to Edison. But my suggestion is, at that point of time, those who had actually contributed in developing the invention, they should have raised the objection and didn't allow Edison to claim that particular invention. Historically, I'm not aware if if there was any opposition to that. But answering the second part of the question, that can there be a patent for improvements if they satisfy the requirement of novelty, inventive step, and utility, even if there is a provision for there is a scope for patenting of improvements.
Thank you, sir. Now I would like to ask Devdeep sir, Devdeep Shikdar, that are you satisfied with the answer, or you have any other counter question regarding the question that you had asked?
No, I'm satisfied with the answer.
Okay. So can we move into the second one?
Please, please.
Okay. Uh, Another question he has asked that as you have mentioned the bistillery, then there are different kinds of names, bistillery like that. So why this kind of counterfeit products like bistillery, etc.
Hmm.
They are not being punished by the original owner bistillery?
Uh-huh. So actually, the authority or the capacity to complain or to file a suit for trademark infringement lies with the proprietor of the registered trademark. So the registered, so I think I'm not sure who is the registered trademark of Bisleri, owner of the trademark Bisleri. Only the registered proprietor of the Bisleri mark can file a suit for trademark infringement. So as a consumer, we cannot file a case of trademark infringement, because if someone is infringing someone else's trademark, then legally speaking, you are violating the property right of the property owner. So, legally speaking, only the property owner can file a case and ask for remedy for trademark infringement. The consumers, at the most, should be aware of it and not use that product. But consumers per se does not have, even though they are misled, but they cannot file a case for trademark infringement, legally speaking.
Okay, so that means if the original owner doesn't file a case, then there is no means of any kind
No,
of.
no, yes. Many a times, what they do is they do not file a case, but they release a public notice in newspapers that there is a counterfeit use. We are not associated with this, but that's not a legal solution actually. So sometimes a brand is so popular that they don't want to file a case against the counterfeiters, because they know that people will be able to identify the product, because prosecuting against an infringing trademark also involves cost. You have to file a case for that. Different cost is involved. So that is why many times these days what is happening is they're not going for the normal justice delivery system. They're not going to court of law. They're going for arbitration. They're going for alternative dispute resolution process. Say they contact the counterfeiters, and by way of a private conflict resolution process they try to resolve it. But again, that has to be done by the owner of the trademark, not by the consumer.
Okay, sir. So Devdi sir, are you satisfied? You are okay with the answer?
Yes, I'm satisfied with the answer.
Okay. So moving into the next question, he has asked the next question, that is a researcher. So should a researcher file his patent first, or the paper submit his paper first?
See, there is a concept called anticipation. So generally, as you correctly stated, that if I say I'm working on a project pertaining to pre-innovation, and there is a conference, and I present a paper on that conference, so it means that the invention is already there in public domain. One ideal way is not to make a paper presentation on exactly that innovation, on the entire aspect of the innovation. Generally, it is advised not to not to make a paper presentation based on the entire invention. You can take a part of the invention and can make a paper presentation. But say you have made a paper presentation, and later on, when you are filing an application, they will show you the publication of that paper and say that it's already there. In that case, if you can prove that it is your paper, then you will be excused, and you have to prove that you are the author of that paper.
Okay, sir. The next question is it possible to file a patent for a work which is already being published in peer review journals? Hello.
I'm sorry
Uh,
for the there was a
okay, sir, should I
okay.
repeat the question?
No, I have heard. Could you hear my answer? So I'm telling that
Yes.
because of anticipation, it is okay. But what is advisable is not to make a paper presentation or not to publish the paper before filing the patent application. Once you file the specification, then you can publish the paper. That is also one option. But even though you have published the paper before, and it is authored by you and you are the person who has filed the application for patent, if you can establish that before the patent office, then there would be no objection to it.
Yes, sir. Thank you. But refer to that question. The another question is that is it possible to file a patent for a work which is already being published in peer review journals?
No, because the person who is the author uh, of that particular paper may apply for a patent. But if some X has filed a particular project and I am now applying for the same thing, patent application, I will not be able to establish that it was my paper, right? So in that case, I cannot take someone else's
Yes. Okay. Thank you, sir. So I would like to ask Mr. Devjit, sir. So are you satisfied with all the answers that Abhishek sir has given, or you have any other questions, sir?
One just last thing. I wanted to ask, sometimes if we cite a line from our own patent or our own piece of work, does it fall under that we are violating that law, violating the patent? Or supposedly, if if somebody has written a book, you said, and the copyright is with both the publisher and the author, or if only the author is the owner. As an author, if somebody, as a person, I cite it, uh, is it under the violation?
Right. So information is available in public domain. In that case, the novelty element would be difficult to be proved. So even if you're citing copyright in the recent guidelines issued by UGC, am I audible, sir?
Yes, sir.
Sir, actually,
Yes, sir.
there is some issue. Now, if you can please continue.
Yeah. So what I'm telling is, see, if you are writing a research paper and you are quoting your previous research paper, even in that case, you need to paraphrase the expression, and you cannot use the same content, even if the earlier author was you, because that is why there is a UGC notification that has come, which is against self plagiarism. So if I cannot use the same content in a subsequent research paper. But as far as anticipation in patent is concerned, so if it is my own research paper, in that case, novelty may be proved because of anticipation, as I already told you. But generally, it is advised not to publish the entire invention through one single research paper before filing of the specification.
Thank you, sir.
Thank you, sir.
Okay, Devjit, sir, you are having any other question?
No, I don't have any other question.
Okay, thank you, sir, for asking. Now we are moving into some other questions, and
Yeah.
these questions are asked by Madam Aisha Chaudhary. So, Madam Aisha, are you there?
Yes, sir.
Okay. So, Madam Aisha wants to know, Abhishek sir, Madam Aisha wants to know, this is her first question, that when an artist or owner will be eligible to resell the right protected by him or her,
Will be. I couldn't get the question. Will be able to.
will be eligible to resell the right protected by him or her.
I'm not able to understand. Resell. Um, Resell
I
what,
would
if you
like,
can specify?
okay, I would like to ask Madam Aisha to please make it clear to sir.
If,
So
if,
I was
yes, yeah. Please go on, ma'am.
I was asking when an artist or the owner of a particular protected rights is eligible to resell the rights to another owner or publishers who want to publish their
No,
own articles.
yeah. So it depends on whether it's an assignment or a license, ma'am. If you have sold the copyright, means if you have assigned the copyright, say you have written a book, you are the first owner of the, as an author, you are the first owner of the book. Say if you have assigned the copyright, okay, if you have assigned the copyright to the publisher, then you cannot, transfer it again to anyone else. But if you have licensed it, for example, you have licensed the publication right for 2 years, then after the expiration of 2 years, you can license it to someone else. Regarding the resale share right in original copies, sir, Aisha ma'am, I would request you to refer to a provision. I'll write that in the chat box. Please refer to
Okay,
this
sir.
particular provision that will help you in understanding the resale share right in original copies. That is section 53 capital A of the Copyright Act. But that is in respect of original copies. It says that in case of a resale for a price exceeding 10,000 rupees of the original copy of a painting, sculpture, or drawing, or of the original manuscript of a literary or dramatic work or musical work, the author of such work, if he was the first owner of the rights, notwithstanding any assignment of copyright in any work, shall have a right to share in resale price of such original copy. So this resale right, as provided in section 53 capital A, that is only for painting, sculpture, and drawing, not for any other type of works. But that is also whether it depends on whether you have assigned or licensed. In case of assigned, there is a, it is as good as, for example, selling your car. But if it is a license, in that case, license is a temporary transfer of the right. Means after some time, you once again gets the ownership and you can sell it to someone else. So license is equivalent to, say, for example, giving your premise for rent or as a lease. So it would depend on what type of transfer it is, ma'am.
Thank you,
Thank
sir.
you, sir. Sir, Aisha madam has another question. The
Yes, ma'am.
second
Yes,
question
sir.
is, can AI derived works be IPR protected?
That's a very interesting question. I recently I'm researching on that question. Actually, I've authored a paper on that. Uh, it's actually difficult to give a one-liner answer to that. There are many dimensions to that question, but I can tell you the present status under the Indian Copyright Act. The way the present Indian Copyright Act is drafted, over IP AI generated works, copyright cannot subsist under the present law. So that's why in India there are no cases where AI generated works have been granted copyright protection. Even the same is the position in United States. But very interestingly, a couple of months back in the previous year, in China, the some code. I mean, I am not sure which code, but a code of China has upheld copyright protection of a AI generative work. But that's why it depends on which country or which jurisdiction you're talking about. As far as India is concerned, in India, as of now, AI generated works are not considered as copyrightable work because, as per the principle of copyright law, the idea and the expression has to be of the same person. So, if I am having an idea of a story, I have to write it. Then only I will be the author of it. In AI, what happens if the idea is generated by the creator of the AI, but the expression is created by the machine. So the same entity is not converting the idea into expression. So that is why, because of some technical reason, AI generated works are not protected as a copyrightable work in India till date. I don't know what will happen in future, but till date it is not protected.
Okay, sir. Related to that only, she has another related question that if we do with the help of AI, then whether will it be considered creative as the IPR will come into play?
Actually, there are arguments both for and against, but there is no one absolute correct answer to that question. Uh, I mean, those who argue in favor of granting copyright protection, they say that it is based on the prompt, so it is someone else's idea, and it should be protected. It's, after all, it's a creative expression, and that's why it should be protected. But those who say that it should not be protected, they also mention the ethical aspect of it. That the copyright protection subsists over original expression which is originating from the author. If you are taking the help of a generative AI to create a creative work, then the expression is not that of yours. So you are technically, you know, claiming ownership over something which is not originating from you. So that is why the reason, uh, you know, there is the mainly there are arguments against ownership of generated AI, and there are other problems also. Even if you consider AI generated work as a copyrightable work, there would be future complications. For example, if someone else infringe a violate an AI's copyright, will an AIB will be able to go in a court and file a case of copyright infringement? Say that is also hypothetical possible. When the court gives the judgment, who will enforce the judgment? Can an AI be able to enforce a decree of a court? So these practical problems are there. That's why I'm not telling that in future there may not be any copyright protection of generative AI, but the way present law is designed, at least in India, so jurisprudentially also there is no copyright protection of generative AI.
Hello, sir. Hello, Abhishek sir. Can you hear me? Hello, hello. Shubhajit sir, can you hear me? Shubhajit sir.
Yes, 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 yes.
I think
Maybe sir is
Abhishek.
having some problem.
Yes, yes. I request all the participants to be there. Please kindly be online. I think Abhishek sir is having some technical issue. Hello, Abhishek sir. Hello. Okay, I would like to ask Madam Aisha that whether your query is resolved or not. Aisha ma'am.
Yes, sir.
Okay. So I would like to request the participants that if you have any other question, you please send it in the WhatsApp, and I would take the questions from there. Any other question, anyone? I think Dr. Abhishek Chakraborty sir has some network issue. So once he comes, only one question will be asked, and then we will conclude the session with the vote of thanks. It will take hardly 10 to 15 minutes. So please be online, everyone. And thank you, Madam Aisha and Madam Mr. Devdeep, for your valuable questions.
Mm, Chintya sir, I had a request to you. Can we get the
Yes,
PPT
yes,
or the
yes, yes.
presentation
I will. I will
into the
ask
chat?
that to sir in the last. Okay, in the last.
Because it was quite
The,
useful and could be used as a
yes, sir.
resource
Yes,
material for us.
yes, sir. Yes, sir. I will ask that.
Thank you. Thank you so much.
Yes, sir. Yes, sir. I have that in my mind. Okay, I will ask. I would request Shubhajit sir, so if he can call Avishek sir and check the update.
He is having some network issue. Okay, let's see.
Okay.
Sir is joining.
Yeah, I'm so
Yes.
sorry for that. Um, I mean, it's such an ironic thing. The internet. I mean, Bangalore is supposed to be an IT hub, but the internet problem is so much. Anyways, is there any other question which I can answer?
Uh, Sir, actually, I am having one question. And
Yes, please.
sir, if I create a logo with my name, so can it be make as a trademark? That suppose I am having an YouTube channel. So
Yeah,
in the YouTube channel, something is being shown. So that topic will be shown under the logo of my name, or suppose
correct.
my channel's name. So
Yeah.
can I make it a trademark or something
Yes,
that
a channel
because
name can be registered as a trademark. But sir, general name, like without proving a distinctive identity, the trademark registry will not be registering it. For example, if someone wants to register the name Amitabh Bachchan, generally names and surnames are not registered as a trademark. Generally, but if you can prove that you have achieved a distinctiveness, acquired distinctiveness. For example, MS Dhoni International School. So in that case, there is a possibility of registering it as a trademark. But my name, a professor in a university, I do not have any other distinctive identity. So then it may not be registered. For example, there are instances of registering surname as a trademark. For example, this Hawkins, right? Hawkins is a surname that is registered as a trademark. Cadbury is registered as a trademark. There's a surname. So, in selected cases where they are able to establish that the trademark has a secondary meaning, Godrej, Tata, right, Birla. So these are surnames, but they are able to establish a distinctive identity. Then only the trademark registry will register it as a trademark. But that does not stop you from using your name as a trademark. I hope you're understanding that, right? So
okay.
even without registering, you can use the trademark, use it as a trademark. And if someone is unauthorizedly using your video or your name, then you can stop them. But there may be a difficulty in registering your name as a trademark without proving distinctiveness.
Okay, sir. Thank you,
You
sir.
can have a
And one,
copyright protection over all the videos which you have uploaded that no one can copy. That would come under copyright protection.
okay,
The logo of your channel, that can be registered as a this thing, as a trademark. The robot
okay,
which you have developed, if you can prove that it's an invention, you can file an application for patent. So there are multiple opportunities for that.
so that is the thing I am asking, sir. The logo for my channel, can I make it as a trademark or not? If I
You can
don't
do
have
that.
any okay, okay,
You
that is
can
the
do
thing,
that.
sir.
There is no restriction on that.
That is the thing, sir. And one
Because
last thing,
channel, for registering channel name, that is not guided by Trademarks Act. That is guided by YouTube's policy. So if you're registering a channel which is already there, in that case YouTube may not allow you to register. So registering a channel and registering a trademark, they're two different things.
sir, actually, I'm having a channel, and now with the help of AI, I want to make a logo of that channel because right now
Huh,
the channel is
that
named. Uh,
that can be registered as a logo, because the
yes,
problem with copyright is that you are protecting expression. That is
yes,
why the challenge is more in respect of copyright law and AI. But even if you're using a logo, whether it's AI generated or whatever it is,
okay,
because trademark is used to designate the origin of the goods, isn't it? So the purpose of copyright protection and trademark protection, they're different. That's why even if it is generated by AI, but you are filing it as a logo. So
yes, sir.
provided that such similar logos are already not registered before, you can apply for registration, provided that the examiners are convinced about the distinctiveness of your mark.
Okay, thank you, sir. Sir, Mr. Devdeep has one request.
Yes.
That is it possible to get the that is soft copy of the PDF that you have shown to us, or
Yeah, yeah. I
PPT
can
that you
I
have?
can mail
Yes.
it. I can mail it.
Okay. So, sir, I would kindly request you to please mail it into the email ID of Shubhajit sir or the Department of Business Administration
Yeah, yeah.
from
I will
which you.
attach it. Yes, yes. No problem.
Okay. Thank you, sir. And I would like to request any question is there? All the participants, is there any question? Okay. So,
I think it's
sir,
already
now
evening, so everybody,
yes,
and
yes, sir.
it's a long weekend. So it's already a festive mode, right? Here
Yes, sir.
I don't have any holiday in Holi and on others, but my colleagues have left. So it's for from tomorrow till Sunday we have a long weekend. From maybe people are also leaving. I think.
So, sir, we are in the verge of concluding our session today. So, before conclusion, I would like to thank all the participants, and that is our principal and vice principal. So, first and foremost, our deepest gratitude goes to our esteemed principal and vice principal. Though they are not present over here, but still their unwavering guidance, support, and encouragement that they gave us to conduct this workshop was very suitable, and their willingness to embrace innovative initiatives and to provide the necessary resources has been instrumental in empowering our department to organize such enriching educational experience. We are also profoundly thankful to Dr. Avishek Chakraborty, our distinguished resource person for today's session. Sir, your expertise and insights into the intricate realm of intellectual property rights have been truly enlightening. The way that you showed us the examples of the that is washing machine as well as the biodegradable and that is sticks, it was very much with clarity that you have shown to us has deepened our understanding and also inspired us to delve further into this vital subject matter. We are privileged to have you, sir, and we are privileged to have this opportunity to learn from you. And we are immensely grateful for your invaluable contributions to this workshop. Thank you, Abhishek, sir.
My pleasure. It was indeed a very good, opportunity to share my thoughts with all of you. Thank you so much.
Thank you, sir. Now, a special mention must be made to the dedicating members of the organizing team, the Department of Business Administration, and all the members of Department of Business Organization are also a member of IIC and who have worked tirelessly behind the scenes to ensure that the seamless execution of this event. All of yours meticulously planning, attention, detailing, unwavering commitment to excellence have been exemplary. Uh, Thank you, everyone. Thank you, each member of the organizing team. Thank you for your dedication and hard work. Thank you, Shubhajit sir. Thank you, Shushoban sir. Thank you, Rupa madam. Thank you, Shamili ma'am. Thank you, Shainika ma'am. Thank you, Somdev sir. Thank you, Rakesh sir.
Thank you so much, Achintya sir, for delivering this vote of thanks. This workshop, without the vote of thanks, it might not be the completed one. So once again, thank you for delivering the official vote of thanks. And thanks to each and every participants who have participated because this particular event, it takes place only due to the participation of various participants, even not only from Tripura. We got the participants from various states of India. So we are thankful to everyone who has come forward and participated in this event. Once again, thanks to all. Now, as I said in the very beginning, that after the session will be over, we'll be having a group online photo. So for that, I request everyone to please make your camera on.
I'm
And
so sorry, sir. I will not be able to switch it on, but I'm very much here. I'm very much here.
it's okay, sir. And side by side, I'll request Rakesh sir. If you are hearing me, please to take the group photo, virtual photo.
I think, sir, it has been
Okay.
taken.
Okay. So thank you once again, everyone.
I hope one day I'll be able to visit Tripura. Till date, I have not been to Tripura. My entire
Definitely, sir.
family has been
Definitely,
to
sir.
Tripura, but except me. So I'm really hoping someday I'll be able to visit Tripura, Agartala during special occasions.
Definitely, sir. Definitely, sir. In the
Anyway,
future
thank you
days
so
also,
much,
we
sir.
will. Thank you, sir. And we will be also looking forward to having you in our upcoming sessions also. We already had few sessions previously.
Absolutely. Sure. Yes,
Previously also
yes.
we had that also was in online mode. Today also we have the session in the
Yes,
online
yes.
mode. In the future days, we will try to have you in a offline workshop or offline FTP, whatever.
Absolutely.
Thank you, sir.
Absolutely.
Thank you, sir.
Thank you so much, sir. I will be
Thank you.
leaving the session. Have a good day, everyone.
Okay, sir. So thanks everyone for your active participation. Now, one request will be there on behalf of every one of us from Department of Business Administration that please, the group that we have formed, the WhatsApp group, please don't leave that group for the next 10, 15, or 20 days because your certificates of this workshop will be uh, given within this period of time only. We will take some time for some technical arrangements. By next 10 to 15 days, all the participants, those who have sent the feedback, or that is, those who have submitted the feedback link, that is, feedback form, uh, will be getting the certificate, and it will take some time. Once again, I'm saying we are taking 10 to 15 days. It might not take that many days, but still, we are taking it. So till then, please don't leave the WhatsApp group. And this feedback link is given in the Google Meet chat box. Those who have not submitted as of now, please submit it. We will be there for the next 10 minutes. So please, by this time, you
Shubhajit,
please submit it. And
Shubhajit sir,
yeah,
one thing that I want to include that after even after 10 or 15 days also, we can keep the WhatsApp group so that
yeah, definitely, definitely.
whenever we organize any such program, so we can send the link or we can send the invitation to into this WhatsApp group so that all the participants can join easily.
Yes, yes, definitely, definitely. No, actually, why I said this because in many of the events we have seen that after just completion of the event, people are just moving out of the group. So for that reason, it's a request on our part that please, till the certificate is given, please don't leave.
Yes, and we hope that all the participants and that you had a great experience and you had a great workshop. So please be there in the WhatsApp group. And whenever we are organizing any other thing, we will be sharing the link and sharing with the invitation to you all. Thank you.
Thank you.